difference pursuant to Article 26 lies in the fact that the organizer of a criminal association was held liable only for those crimes which had been committed within the framework of the criminal association's plan, and not for the transgressions of its members. An organizer who did not participate in the commission of a crime could have been held responsible only if that act had been envisaged by plan, and this corresponds with the fundamental form of JCE category 1, but certainly not to its extended form, according to which an accused is held responsible even for crimes that he could only foresee. In that the character of foreseeability has been objectivized and fails to take into account the subjective traits of each and every accused, or the objective circumstances of the context which existed tempore acti, at the time when the crime was committed. The task of the prosecutor in a socialist legal system was nevertheless more challenging and demanding than the task of the prosecutor at this tribunal. The former had to establish, or rather identify, a direct perpetrator and subsequently a causal link, or nexus causalis, between the perpetrator of a crime and the alleged planner, or a superior position, the member of the alleged criminal plan. In our example, in the category 3 of JCE, the prosecutor does not even deduce evidence to prove that link, so that the responsibility of a perpetrator behind the perpetrator is presumed by the foreseeability of the consequence. Needless to say, such a procedural and legal situation is particularly conducive to the work of the prosecutor and greatly facilitates his procedural duties, whereas on the other hand it is particularly prejudicial for the accused because his guilt is actually presumed and equalized with the objective responsibility, which in legal terms exists only in some civil law cases in connection with the use of the so-called hazardous substance. It is not known in criminal law cases. The accused seems to be in a position where he must prove his innocence instead of the prosecutor having to prove the former's guilt. Such a procedural situation derogates the presumption of innocence. Allow me to remind the Honourable Chamber that the UN Secretary General presented his report pursuant to the UN Security Council Resolution number 808 to adopt the statute of this tribunal. On that occasion, the Secretary General clearly emphasized that the principle of legality requires from an international tribunal to apply rules of international humanitarian law which had unequivocally become an integral part of international customary law. In terms of the tribunal's subject matter jurisdiction, there is no dispute that the Geneva Conventions, the Hague Conventions, the Convention on the Prevention and Punishment of the Crime of Genocide, the Statute of the International Military Court in Nuremberg, as well as the resolutions of the International Law Commission from 1950 are its sources of law. Any other application of law or precedents beyond the aforementioned legal sources are always partially disputable, and the trial chamber should necessarily provide a reasonable legal explanation for the application of certain legal institutes unknown to the aforementioned generally adopted international humanitarian law. In this case, the defense is justifiably concerned about the incriminations that the prosecutor imputes to the accused, which point to the legal construct of expanded JCE. This is because there is no single provision in this tribunal's statute or in the aforementioned indisputable indisputable sources of international humanitarian law where the legal institute of joint criminal enterprise is mentioned. We have already heard counter-arguments according to which JCE is not even a separate crime, but rather a form of criminal responsibility or command responsibility which arises from the provisions of Articles 7/1 and 7/3 of the statute of this tribunal. The defense categorically refuses to accept this legal explanation, and there will be legal arguments to corroborate the position of the defense in this respect. Individual criminal responsibility of a natural person for crimes prosecuted according to international law has been unequivocally applied in the case law of ad hoc international tribunals. This tribunal has established 5 types of criminal responsibility. 2 principal ones, direct perpetration on the one hand and planning of a crime on the other, and 3 accessory ones, aiding, abetting, and any other form or action which has contributed to the planning or commission of a crime. The theory of command responsibility, which arises under the Anglo-Saxon common law doctrine or vicarious liability, is founded in the provision 7/3 of the statute. The appeal chamber in Tadic case established by way of interpretation per analogiam juris the construction of JCE as an alleged form of legal responsibility. In that, one should bear in mind that the doctrine of vicarious liability originates from the Middle Ages as a responsibility of the superior for the damages inflicted upon third persons by their subordinates, pursuant to the maxim respondet superior. In the Lalic case, the trial chamber established the following elements which constitute the term indirect command responsibility according to the standard comments of the legal profession as follows. Functional, dealing with superior's position and a hierarchical relationship with his subordinates. Cognitive, the superior's awareness that a subordinate is in the process of preparing to commit a crime or a crime has already been committed. And operational, a failure on the part of the superior to take the necessary and reasonable actions to prevent crimes or punish the perpetrators thereof. The standard of fact and law has imposed a heavy burden on the prosecutor to prove his case. Hence, the prosecutor has opted for an easier route, albeit a problematic one, from the legal point of view, from the standard of fact and law in terms of joint criminal enterprise. As early as 2000, it was noticed that 81% of all indictments presented before this tribunal were based on the JCE construct. Why was that? By applying this construct, the prosecutor doesn't have to prove the cognitive and functional elements from the Lalic case, whereas the subjective element of the crime as a form of guilt, the so-called dolus eventualis, or an evil intent, is formulated so as to imply that the awareness of a possible commission of a crime encompasses also collateral crimes that the superior didn't have any knowledge of, but allegedly he could have foreseen them due to the nature of a criminal plan or objective. In Tadic's case, the trial chamber was not able to establish that the accused had participated in the killings of 5 Muslim civilians in the village of Jakšić near Prijedor, Bosnia and Herzegovina. The killings had been committed by Serbian paramilitary troops engaged in the process of ethnic cleansing. Deciding on the prosecutor's appeal on the part of the first instance chamber's decision exculpating the accused from that charge, the appeal chamber reached a lucid decision and invented a systemic model of individual responsibility, quite clearly unfounded from the defense's point of view, and the chamber based that model on the provision of Article 7 of the statute. To arrive at its decision, the appeal chamber had carried out an analysis of the jurisprudence of national courts and international tribunals after World War II, with a view to establishing the postulate of indisputable element of the international humanitarian law, which had been laid down by the UN Secretary General in the previously quoted 1993 report. Likewise, the appeal chamber had established that the term joint criminal enterprise is entrenched in a minimum of 2 international treaties: the International Convention for the Suppression of Terrorist Bombings, dated 1997, and the 1998 Rome Statute of the International Criminal Court. Nota bene, Your Honors, both of these legal documents were drafted after the incriminated acts had been allegedly committed by the accused in 1995. Also, the appeal chamber established that the doctrine in the implementation of a joint intention is entrenched in the national laws of many states. In short, the appeal chamber has established that the case law existed and that consequently joint criminal enterprise as a form of responsibility has its firm foundation in humanitarian law. Contrary to the above, the defense believes that this conclusion is certainly not conclusive. In the Tadic case, which is what the appeal chamber analyzed, there is no evidence that the trial chamber based its judgment on that legal construct. JC does mention a joint plan and proffers conjectures as to whether and in what way the competent court had really taken into account cases from such indictments. But this is by no account sufficient to establish that the theory of the JC tempore criminis, which means that it coexisted with the crimes imputed to the accused, was part of international law. There is only one national court judgment, Italian court in Ottavio 1947, in which the court based the guilt of the accused on something similar to the concept of extended JC, but that judgment is not, nor can it indeed be, an unequivocal proof that JCE is entrenched in international customary law. Subsequent judgments in Vasilievich, Kvochka, Forungia, and other cases have established the institute and the term JCE in the tribunal's jurisprudence. In that, particularly interesting is the decision in Nordenich case. The defense in the case lodged an appeal challenging the tribunal's jurisdiction, and the trial chamber in that case confirmed its own jurisdiction with regard to the interpretation of the forms of criminal responsibility allegedly according to the statute of the tribunal. The introduction of such judicial practices at the tribunal could not go unnoticed among the professional public. Many commentators have observed rather cynically that the judges of the tribunal stand to reap multiple benefits from the application of the legal construct of JC in cases which would have otherwise been very complex. The contribution of participants has to be established in much broader terms than if the postulates of legality were applied.